Well, in every criminal trial, legal issues arise between the prosecution and the defence, which need to be dealt with by the judge in the absence of the jury. Now, certain matters can be trashed out in pre-trial hearings before a jury is sworn in to save time, but there are some issues which will be heard while the trial is in progress. In Richard Satchwell's trial, the defence raised a legal issue in relation to the charging of Richard Satchwell with the murder of his wife Tina Satchwell on October 13th, 2023 at Cove Garda Station, and specifically the admissibility of his reply to the charge when he said guilty or not guilty, guilty. His barrister effectively said at this critical stage during the process of his detention that he was entitled to legal advice, but senior counsel Brendan Grehan said no one sought it for him, and he called a number of Gardaí to give evidence to the court. The defence claimed that this was evidence that was more prejudicial than probative, asking the court to take into account that someone had given information to the media so that before Mr. Satchwell had even been charged or seen his solicitor, that two journalists were tweeting about it. And the defence argued that this reply after charge should not be heard by the jury. In his ruling, Mr. Justice Paul McDermott said he was satisfied that Richard Satchwell understood the nature of the charges and that the words that were spoken were recorded accurately. He said he didn't find the fact that his solicitor was not present at the time Mr. Satchwell was charged affected the fairness of the process, and he said that the reply given by Mr. Satchwell had to be dealt with in context of what the accused had already said in his Garda interviews when he told investigators that there would be no trial, there would be no jury, because he was going to plead guilty. The judge said that gave his reply evidential value, and he ruled that this evidence should be heard by the jurors.